I'm Jen Marley. I'm a Senior Associate in our Charities team here at Burkitt's, and I've assisted a number of trustee boards to navigate and resolve internal disputes. With me today is my colleague Sara Sayer. Sarah's a litigator, and she heads up our Public and Administrative Law team. Whilst we always hope that a trustee dispute does not escalate to full-blown litigation, we find it really helpful to work closely with Sarah's team from the start of any dispute or potential dispute. In this webinar, I'm going to talk about what we mean by a trustee dispute. I'll then take a look at a well-publicised recent example and how your constitution can help or hinder you during a dispute. Sarah will then talk through some of her experience of managing disputes and give you some tips and tricks for bringing them to a resolution. Finally, just to apologise, I have a cold today. I'll try and keep the disruption to a minimum. So what do we mean by a trustee dispute? As most of you know, a trustee board generally makes decisions by majority vote. A well-functioning charity trustee board should ask questions, challenge assumptions, and that can at times lead to expressive debate and discussion. These are normal functions of a trustee board, and provided everyone is acting in the best interests of the charity, that shouldn't prevent the trustee board from reaching a majority decision and moving forward with the matter at hand. However, there are times where debate and discussion start to move into trustee dispute territory. For example, where the trustees become entrenched in their positions and can no longer reach a majority agreement on a matter, or where one or more trustees feel strongly that a decision has been made in breach of trustee duties, or otherwise not in the best interests of the charity. Disputes can, of course, also arise where proper processes have not been followed, and actions have been taken that are not in accordance with the governing documents of the charity. Where that happens, it can start to have a seriously detrimental impact on the running of the charity and potentially damaging to the reputation of the charity, particularly if it's picked up by the press. So let's take a look at a real-life example of how something that starts with a procedural irregularity in a trustee vote can snowball into a dispute spanning a number of years and becoming very public. I'm going to use the dispute in the Actors Benevolent Fund as our example today. The Actors Benevolent Fund was originally founded in 1882 by Sir Henry Irving. It was established in order to provide relief and assistance to actors and stage managers who could not work due to accident, illness, or old age, and it also provided support to their spouses, partners, and dependents. So far, so good. The trustees of ABF were elected at its annual general meeting, and at the AGM in 2022, a vote took place that purported to remove a number of very long-standing trustees, including the actor Dame Penelope Keith, who had been president of ABF for 32 years. It was argued that there were procedural irregularities with the calling of the vote, and the outcome was seen by some members of the charity as a coup, with the old guard being ousted and the new guard being ushered in. Following that vote, two camps became entrenched within the charity, and a dispute arose as to who were the properly appointed trustees. The Charity Commission came to hear about the dispute and was told that due to procedural issues with the trustee election, the charity had no properly appointed trustees. This prompted the Charity Commission to open a regulatory compliance case. So a regulatory compliance case is not a statutory inquiry, but it does allow the Commission to make investigations into the management of a charity and requires the charity to provide certain information and documents to the Commission. This often leads to the Commission giving the charity regulatory advice. In 2023, despite identifying a breach in the AGM process, the Commission formally appointed those individuals who had received the most votes at the AGM to be the trustees of ABF, with instructions that the charity should hold a new vote within a year. So this meant the old guard were out and the new trustees were in. The Commission commented that dispute had been very harmful to the charity's reputation and its ability to operate effectively, and it hoped and expected all parties to this dispute to move forward together in the interest of the charity. You might think that would resolve the matter, but the dispute rumbled on. The two entrenched camps remained in the charity, and they fired barbed comments at each other about previous failings in the management of the charity and how the charity had now been hijacked. The trustees, who had lost their position, made a formal complaint to the Charity Commission about its handling of the issue, and in January 2024, the Commission held that many of those complaints were valid, including that it had failed to find the former trustees had been validly removed before it appointed new trustees. Soon it was time for the charity to hold new trustee elections. The result of that election was due to be announced in January 2024. However, the charity found irregularities with the online voting for that election, with a large number of votes coming from a single source. Those irregularities were significant enough to cause the charity to contact the police. After investigation, some 166 votes were discounted, and the current Board of Trustees were confirmed as elected. You might hope that the dispute was now resolved and the charity could focus on its work and its beneficiaries. However, just 2 months after that vote, the newly elected chair stood down, citing time pressures, and the members of the original ousted trustee group continue to express dissatisfaction and have indicated that further action may follow. This is an example of how a procedural irregularity on a vote can snowball and become a long-running and disruptive dispute. Only time will tell when and if this one is finally put to rest. So what can your charity do to help avoid disputes? There is, of course, an argument that if you get the right people on the board in the first place, there's less chance of a dispute arising. However, in practice, that can be difficult to achieve. Board composition, personalities, and strategic priorities of the charity can change over time. As a lawyer, my recommendation is to make sure that your governing document is in good shape to help you if this sort of situation arises. And there are two main aspects to that. The first is making sure that procedures in your governing document are clearly set out and are not open to multiple interpretations. We understand that the ABF dispute essentially stemmed from the fact that procedural points in the governing document could be interpreted in a number of different ways. The second point is to consider what provisions do you have in your governing document for resolving a dispute and/or removing a trustee. Are these clear? If a dispute arises, what steps should you take? Does anyone investigate the matter? If so, who? And is the outcome of any investigation binding or merely advisory? If you need to remove a trustee, are there clear procedures for doing so? Who makes that decision and how? Whilst no charity wants to believe that a serious dispute will disrupt its work, I think the ABF case shows that disputes can escalate quickly. Once they have escalated, it can be very difficult to get the charity back on track.
Jen, one of the questions we've actually received in advance is, can you remove a trustee?
That's a really good question, Sarah, and it really depends on the structure of your charity and what you've got in your governing document. So if you've got a charitable company, then there's a statutory power for the members to remove a charity trustee, provided they follow the procedure in the Companies Act. If you've got a charitable trust, they have a statutory power to replace trustees in certain circumstances. For other charities, or for trusts where you don't want to replace someone, you just want to remove someone, you need to follow the procedures in your governing document. And if they don't cover the situation you're in, you can find yourself in a really tricky position of having no formal power to remove someone. And then you may need some input from the Charity Commission or the court.
Thanks, Jen. And another question we've received is, actually, can you suspend a trustee?
It's another really, really good question. And it's perhaps a trickier question. So whether someone is a charity trustee or not is driven by their function rather than their title, with the charity trustees having the general control and management of the charity. If someone has been suspended, that puts them in somewhat of a grey area, which can be quite difficult for both the trustee and the charity. So generally, unless there's specific provision in your governing document for suspension, we would say it's better for the trustee to resign or be removed, even if they intend to come back on the board later, as this provides certainty about who is the trustee at a particular period in time. So it might be worth mentioning at this point about the Charity Commission's role in all of this. So while the Charity Commission was involved in the ABF dispute, The Commission's starting point is that charity trustees can and should resolve internal disputes themselves without Charity Commission involvement. And this is often the response, even if the charity has reached out to the Commission and asked for help, the response back is often, you need to take further steps to resolve this yourself first. The Charity Commission can only get involved in an internal dispute if there are no validly appointed trustees, in which case it can use its power to appoint, or if the trustees can show the Commission that all attempts to resolve the dispute have failed. Even then, the Commission will only get involved, really, if there's evidence of misconduct or mismanagement that's put the charity's funds or users at risk. If that's the case, then the Commission may open a regulatory compliance case and provide guidance. And if that guidance isn't followed or doesn't resolve it, then it may then lead on to a full statutory inquiry. If a dispute does, of course, proceed to formal litigation, the charity will need Charity Commission consent before starting those proceedings. Sarah, maybe you could talk us through some of your experience about managing some of these disputes.
Of course. And you can see how difficult the ABF case was in terms of the Charity Commission itself found it hard, because it ended up having to give apologies for certain aspects of how it had handled the case. I think the ABF case very much strikes me as that tension that you see in so many charities about the sort of modernising agenda and whether the board is being carried forward together in forging that charity forward. And I think, as with many board disputes, you've got the position over here and a position on the other side, and the truth is often somewhere in the middle ground. In terms of what we see in the disputes we handle, as with many relationships, you don't think they're going to go wrong until they actually do. And I've been advising in the dispute sphere for over 24 years. And actually, the thing that always strikes me is it's not machines that drive disputes, it's people and it's personalities. And actually, charity board disputes are often a manifestation of some kind of malaise on the board, some issues around functionality, or more precisely, perhaps there's an aspect of dysfunctionality on boards. Sometimes I will concede that there are people who are very difficult on a board, who are maybe of the sort of persistent, vexatious complainant ilk, and that's a talk in itself and something on which we've been doing quite a lot of work as a team. But the point is, if these difficult personalities are on the board, then actually it probably will impact in one way or another on functionality. So what do I mean by a healthy board? Because I think in healthy boards, there tend to be less disputes, because there's very often a very healthy chair relationship with other trustees, with the CEO, with the senior leadership team, etc. And what do I mean by a strong chair? I'm not talking someone who's dominant and bulldozes through their ideas and sort of tramples over other people, but a truly strong chair is someone who works towards brokering consensus. And they are crucially ensure that everyone is listened to and everyone is heard and everyone has a voice. And actually, something that's very pertinent in board disputes is you look for those people that are perhaps being quiet, because, do they disagree? Have they got a view? Have they got a view that they don't think is coming across enough or not being listened to? And actually, something that good chairs will do is they'll have conversations behind the scenes, one-on-ones, to find out, what's happening and what the issue is, etc. Because as you touched on earlier, Jen, that there absolutely needs to be debates on charity boards, because the role of a board is to be the critical friend of an organisation. It has to scrutinise. And I think one of the hallmarks of a high-performing board is that people will ask questions of each other and also of themselves. There will be a high level of self-reflection in a strong, highly performing board. But I think the point is, and this sometimes gets lost, is that when you do ask questions or you are scrutinising, it's about how you do it, the manner in which you do it. You have to do it respectfully, courteously, and often diplomatically. Because a weak board will, when people don't ask questions, or they can't ask questions because perhaps there's someone that's silencing them, or it's frowned upon that they're asking too many questions. And I think this all comes down to board dynamics, knowing your board. The trustees and the chair and the vice chair all have to know each other, how it works. What are your risk appetites? What are your biases? The overt biases are probably really quite easy to see because people are normally very keen to point them out, but also you need to be attuned to perhaps what the subconscious biases are that could be influencing decision making. And actually, when you establish things like that, it's about addressing the issues head on, is what we find, in terms of if the majority of the board are very confident that a certain strategic direction needs to be followed, but there's a couple of trustees who perhaps disagree. It's about understanding why they disagree and working with that. It might be, for instance, they're of the data scientist mold and they just are very driven by data, by empirical evidence. And so someone needs to sort of work with that and say, what is it that you need to see? Can we find it for you so that you can at least consider that, etc.? Because we find that it's all about nipping things in the bud before these disputes actually escalate. And in terms, Jen, you asked about experience. Just looking at some of the cases that this team's handled over the last couple of years with the charities team, is that some feedback is that personality associations never really help disputes. There might be a cathartic element, and there may be an aspect of bloodletting that needs to occur in a process, maybe early on. But actually, it's all about encouraging people to move from the subjective emotional reactions onto the objective responses and focusing on the solutions and how you objectively resolve matters. Because another thing that never fails to amaze me in dispute handling is how many people don't actually ask for what they want or don't say what they want. And actually, if you don't understand that, it's very hard to work with the issue and resolve it because you don't actually know what you're trying to resolve. And when people talk in riddles or they don't mention elephants in the room, it can just sort of delay resolution and further entrench people. And another thing that we've really seen on the cases that we handle, it's about avoiding the tit for tat and the endless streams of consciousness letters, etc., and emails, and rising above it and constructively identifying what are the key themes, what are the issues that we need to tackle collectively together. And I think that comes down to dialogue and communication, which is obviously absolutely key. Keeping people, the relevant people, informed, keeping them appraised as to issues, and keeping them updated as to progress, etc. Another thing that we've seen on some of the cases that we handle, it tends to be more in the small to medium sized charities, is founder syndrome. Those people that have perhaps set up their charities using their own land, using their own resources and assets, etc. And then things go wrong and they just don't understand that the charity is actually a separate legal entity with its own rights and obligations. So I think there's still an education piece around that we see. Another key issue that is relevant for boards is making sure that the trustees are actually walking the floor and getting under the skin of an organisation, not interfering, and I'm very keen to point out not interfering, but just listening to understand and observe. And I think that really makes a difference in terms of the effectiveness and efficiency of managing board disputes. In terms of some of the disputes that we've seen for significantly really large charities, it's all well and good when all the boards getting on, but actually it's about having procedures for when they're not, and they haven't always got those, as again, as you mentioned earlier.
So have you got any particular tips or tricks that people can use to help manage these situations?
Yes, I think firstly, again, as you've alluded to earlier, it's about having clear processes and procedures, because if we look at a procedure from a charity and we can't understand it and we're doing this work day in, day out, then the chances are people who aren't seeing them as often as we do probably will struggle. And I'm a significant advocate of having a single issue board meetings or special away days, etc. Because being a trustee myself, I know how packed board agendas are. And actually, I think it's during the course of a year having single issue meetings where, for instance, as to disputes, a board will sit together and say, OK, if something goes wrong, what is the mechanism that we're all going to agree that we're going to use to resolve it? And when disputes do materialise, it's also about reviewing policies and procedures to see where did something go wrong, how can we perhaps tweak this procedure or amend it to try and manage and minimise the chance of this happening again, and learning from the lessons that you've experienced. Because otherwise, as they say in sort of litigation land, if you just keep on swatting mosquitoes and don't actually deal with the swamp itself, then the mosquitoes are just going to carry on breeding and you'll have more disputes. So secondly, I think recording and capturing decision making and justifications of decision making is really, really key. And it's something that the Charity Commission are very, very keen on, in terms of when charities put in serious incident reports because there's disputes happening within their organisation, and the Commission perhaps follow up with questions. The Commission are very focused on understanding what the minutes say, whether the different sort of thoughts and viewpoints were recorded, etc., and how decisions were arrived at, what's the justification for those. So linked to that, thirdly, emails, very prevalent amongst trustees who are often, trying to manage these issues outside their ordinary day job, etc., at weekends, evenings. It's a obviously critical way that trustees communicate with each other. And I would just implore people to make sure that they're in the right sort of zone of contemplation when they're sending emails, drafting them, reacting to them, reading them, etc. Because it still amazes me what some people write in emails and then they start getting scrutinised by others, by the Commission, in courts, etc. And I think sometimes people perhaps regret the haste with which they replied and the manner in which they replied. And I think it's important just to stand back, reflect before responding on some of these issues. Fourthly, if lawyers are involved, then you very much have to start thinking about legal and litigation privilege, and issues such as who the actual client is, who the lawyers are advising, and crucially, who sees what and who's entitled to see what. And that's very fact specific. So it really does need to be applied to the scenario and the dispute that's in question at that point. And then lastly, I think an absolutely key point, learning point from the cases we handle, is if the board is creaking and there is a dispute that's sort of circling and brewing and escalating, it's about thinking about what work you can do early on to try and manage some of these issues proactively and preemptively. That might be work with individuals, it might be work collectively as a board, it might be coaching of some individuals or coaching of the board, some kind of facilitated meetings to have someone external come and try and work through the issues with the board, or even utilising tools in the alternative dispute resolution toolkit, such as a more formal mediation and having a mediator come and work with the board. Because actually, it's all about keeping the relationship on track. And as we saw in the ABF case, the Charity Commission was particularly exercised by this case because of the impact it had on the reputation of charities, because obviously the Charity Commission is so keen and is a guardian of the reputation of charities, because as soon as that's damaged or undermined, that impacts on the public trust and confidence in charities, and therefore that goes directly to whether people are prepared to give their time and their money to the charitable sector and charitable causes. So I think very much sort of in concluding comments, when there are disputes, it's about those involved realising this isn't about self, it's not about personal agendas, but actually you're all together in the charity working for the benefit of the charity and for its beneficiaries.
That's great. Thank you, Sarah. I think that's all we have time for today. But if you have any further questions, please do send them in and we're really happy to come back to you directly. So thanks very much for joining us.